one of the business driver or regulation driver that you have to uh, to to take consideration in data governance is about the law. And when we talk about the law that have heavy fine and heavy punishment is about the privacy law. Now the second module we will talk about the Personal Data Protection Act of Thailand. First of all, I will differentiate about the security and privacy. It's not the same, but it should be together. Let's imagine you have your own house, and your house about your area, you have the strong wall, strong fence, strong fencing, high fencing, with the high standard of material. No one can walk can walk into your house. You have security. But if your house is built by the mirror, by the transparent wall, that everyone from the outside can look into your bedroom, look into your bathroom. That so you don't have privacy. So to conclude, if you have high security, it's not guaranteed that you have privacy. But if you don't have security, absolutely you don't have any privacy about your house. So these two things have to be together. So if something in your house is about your data, your personal data, you may expect that your data have to be stolen, have to be picked it by other person, and you may expect that your data have not been looked at, just see, have not be looked at by another person too. There are some intersections about the security and privacy. Security emphasize about the confidential, integrity, availability of the data, but privacy is refer about the how the organization process your data, how the organization manage your data, and how organization collect your data that can be linked or linkable to another data. For example, if we talk about the PII about his personally identifiable information. When we're talking about PII or somewhat called P2, PII you may think about citizen number, first name plus last name, first name with last name, maybe driving license number or passport number. But I will when you think with me, if you have someone's birthday, conceived of day, with month, with year, if you know about the postal code of someone, and also if you know the blood group ABO, and just 3 fields, these 3 fields may be filtered out the data that link to only one person, probably. If the data is not really large. And let's imagine the hacker does not have your primary key, your ID, your name, your first name, last name, but the hacker can hold your birth date, hold your blood group, and hold your postal code, and they can link to another database that probably breaches, and they will find uh, they they may find your identity from another data linked to another data. So this accessibility is about it. The organization provide the correct measurement, correct safeguard that the data have not been linked to another data to identify the personal data. The data protection principle, they have some principle. I suppose that someone can search to Google and we'll see these 6 principles not difficultly. The first one is lawfulness, fairness, and transparency. When to use another data, someone's data, you have to inform. You have to inform, and not just inform that you will use. You have to inform about the detail how to use with the legality or lawfulness. One thing that you have to inform is the purpose. So the purpose of the processing or purpose of the data that you have to use, you have to limit the purpose, not broad purpose, and the purpose will impact what the data you needed to collect. You have to minimize the data that you collect. The data subject or individual have the right to correct, to justify their data. The storage limitation, the organization have to limit the storage time, have to provide the timeline when how long the organization will collect or delete your data. Integrity and confidentiality is related to the security of the data. Have to be stored, have to be breached, something like that. The structure of this law consists of 7 chapters, but this card is not about for the law person. So I will just briefly some important principles of this law about the data protection, the right of data subject, and the penalty and civil liability. Actually, in chapter 1 and chapter 4 is related about the national authority of Thailand who have to decide or who have to be judged about the case, something like that. Okay. The announcement is first announced on 2019, 27 May. From initially from 28 May 2019, and 1 year later, the organization had to prepare to comply the law. For example, perform the data discovery, perform the data flow, create the data protection impact assessment. If you're not familiar of this word, you may think about the risk assessment, but focus on the privacy of the person. Okay, and you have to appoint the PO. That's it on the between 2019 to 2020, but maybe fortunately or unfortunately, on last year they postponed for 1 year, and this year they postponed it again for another 1 year. So we will face this law fully function up next year in 1st June 2022. The reason of postpone may consist of the COVID situation and also the they say that the organization may be just a public sector and SME is not ready to comply. Territorial scope of this law. This text is stated in the law in the translated version. But to simplify, scope has two scopes. The first scope is if data controller, let's say the organization, if the data controller is in Thailand, the correction in any place, anywhere, have to comply this law PDPA. Another scope is if the organization is outside in Thailand, the activities that have to comply PDPA have two activities. The first one is the offering goods or service, whether the payment is made by the data subject or not. Another reason is it's about the monitoring of the data subject behavior. So if you the mobile application or create a social media application that offers service, offer goods, offer product, or monitor behavior such as keep GPS location, behavior of the internet surfing, mobile surfing, you have to comply this law. Naturally, when we talking about the law, we will look for the exception first. Exception is that if the person made by themselves, not included, public authority with the security of public security, including duty of prevention, suppression of money laundering, forensic science, cybersecurity is accepted. A person of juristic person, not included. House of Representatives, Senate, Parliament, not included. Trial and adjudication of court, legal execution, something about the legal reason, not included, and also credit bureau. And however, those 6 exceptions shall also put in place of security protection. This is the word is stated in the law. Okay, this exception. Stakeholder in PDPA. There are some terms, some technical terms that you have to know. The first one is the data subject. Data subject is natural person. So the name of the company is not it is not the scope of PDPA. But if you correct the name of CEO of the company, it may state it may be included in PDPA scope. The data subject concerns about the natural person whose personal data is collected, retained, or processed by data controller. Who is data controller? Data controller is naturally the company, the organization who correct, who process, who analyze, who archive, who report it or delete the personal data, and in some case, data controller may hide data processor. The data processor is outside organization that work for data controller. For example, I'm working at Mahidol University. So the Mahidol University will be packed as one data controller. So there is no data processor inside data controller or Mahidol University. But if data controller or Mahidol University hire the outsource or collaborate with another university to process, to collect, or to report the data of student of the university, those outside organizations are data processors. Personal data in the law state that personal data means any information relating to an identifiable natural person. For example, name, ID number, location data. Okay, name, understand. ID number is okay. Location data. Okay, maybe asset. Online identifiers such as email, such as IP number of your internet surfing, something like that. Online identifier may be include about the biometrics. For example, biometric maybe your fingerprint or your facial recognition, something like that. It may be linked to psychological, genetic, mental, economic, culture, or identity of that natural person. Just look the diagram on the right. So the information, personal information, and some personal information is a personal identifiable information, and the subset of them is a sensitive personal identifiable information. In each law of each country, there may be stated different scope of the sensitive PII. But anyway, for the general principle, PII is just the attribute that can be linked that can link to one person, and sensitive information is about the attribute that may be affect about the reputation or may make the data subject feel uncomfortable to that everyone know about the data. It's about the protected critical infrastructure, control and classify sensitive security, something like that. So about the sensitive PII is about the some of status, for example, criminal status, marital status, something like that, and also the maybe date of birth, maybe the health record. But in PDPA of Thailand, they have to, when you have to process, when you have to correct, when you have to have the authority to use the data of another person, you have to identify that what is the reason or what is the lawful basis that you collect it. As a researcher, I suppose that everyone familiar about the word consent. Consent in Thai is การขอความยินยอม but consent in the law is about the you have to ask the permission to use the data, but it's just the one lawful basis among the 7 lawful basis of this law. Other 6 lawful basis is a scientific historical research. So if you can classify the basis of your collection, of your processing in the other 6 lawful basis, not consent, you have not to be asked for consent. But in scientific or historical research, it's about the research of history, not any research. Without interest about life, about your health critically. Contract is about the necessity of to use the data. For example, if you register as a new patient in medical health record system, you as a data controller may want to know that the blood group. For example, if you don't know this information, you cannot provide appropriate service for the patient. So in the contract is something that you have to collect, you have to process. If you don't have this data, you cannot be provide the service for data subject. Public trust, legitimate interest, legal obligation. For example, public trust is about that you have the legal, the law that protect that you have your duty, you have some duty to do about this. Stating the law, that's public trust. Legitimate interest is about the interest or benefit that your organization have to obtain. For example, I locate my CCTV for security reason. It is a legitimate interest. Legal obligation. It is the law that the data controller, not specific organization, the data controller have to do something. For example, as an employer have to transfer or send the data about the salary of the employees to revenue department กรมสรรพากร for example. But public trust is about the duty of specific organization. For example, the revenue department have to process the data, and then the salary data that have been sent from the employer, for example. So if you can pick or state the reason of usage in those six lawful basis, you have not to consider to consent basis. But if you cannot identify or judge that your purpose can be categorized in those six bases, you have to collect the data to your benefit. You have to ask for consent. But the consent have something that you have to be aware. For example, you have to check that consent is the most appropriate lawful basis for processing. You don't have if look as a web form in the web page, we infer from silence. You not have to be pre-tick box or inactivity. Another consideration is the consent have to be freely given, informed and explicit. So if you ask for consent, the data subject have the right to decline, to not accept your consent, and have to be clear. Is not the same of the term and condition when we register for Facebook, register for application for e-banking, and have the long text about one page or two pages, A4, and naturally we don't read it and we scroll to the bottom and click OK. The consent is not something like that. The consent have to be clear and not technical term. And another one that really challenge is about ease of withdrawal. So if you ask for consent and you have got consent, the channel of consent withdrawal have to be easy equally with the equal to the process of you when you get the consent. Okay, this is have something that you have to do about the consent. So you see that if you decide the purpose of the processing the lawful basis to be consent, you have to to do some to do something to do several things. You have to uh, you have to revise to redesign the template, the document, the forms, and also the web form, the paper form, and also you have to provide the channel to consent withdrawal. About the sensitive personal data in Thai is ข้อมูลส่วนบุคคลที่มีความอ่อนไหวหรือละเอียดอ่อนนะครับ this bullet is stated in the law explicitly. Racial, ethnic, origin, political opinion, cult or religious, xenophoby, sexual behavior, criminal record, health, data, disability, trade union, biometric data, and genetic data. And of any data which may affect in the same manner, or of any data that can be linked to this sensitive data. If the data you collect or process is sensitive personal data, there are extra lawful basis. The first one is explicit consent. Contrast with the general consent. General consent have to be written in paper, in web form, but in some situations it may be conducted by the verbal consent too. But if you process the sensitive personal data, you have to get the explicit consent only in paper, only in digital file, and have to be authentication before signing. And other lawful basis about the vital interest, social protection, manifesting made public legal claim, and some legal obligation. It may be it consists of preventive or occupation medicine, public health, social care system, scientific archiving, history, research, and substantial public interest. The data that you collect from any other source, you cannot do it except where you have informed data subject of the collection. For example, it may be funny, but for the researchers, it is very burden. If you collect the data from public website, for example, public Facebook, public Twitter, I highlight about the public Facebook, public Twitter, public web board, maybe in Reddit, maybe the Patit.com. Whether it's a public data, but you have to inform the data owner, maybe the website owner, and if the data have to be consent, you have to inform and ask for consent. Or another option, if the collection fall with the exception for consent, you can do it. Another consideration, and is the data subject right, is about the transfer. We call cross-border transfer. Data transfer is about how to transfer the data to another country. Basically, the third party country can ensure adequate level of data security for the country territory organization. For example, uh, if our university want to transfer the student data to foreign university, if that university located in EU and the university can provide the document, the evidence that they comply their laws such as GDPR, so the transfer can be done. But there are some exceptions or some derogation. So based on appropriate security safeguard and based on derogation, derogation is about some of the legal basis. For example, you already ask for consent for contract for public interest, something like that. But in the second option, you have to consult to the committee, the national committee. Okay. The right of data subject in this law, I stress in this law because in GDPR is a little bit different. But in this law, the data subject has the right to be informed. So when you use, you have to inform by policy notice, privacy notice, or consent. Right to access, right to object the use of the data, right to be erasure, and right to be forgotten to, right to restrict the processing, right to edit or rectify the data, right to data portability. So one of the challenges is about the data portability. So the organization as a data controller have to transfer the data subjects data to another organization. It's not the duty of the data subject by themselves. Another role of GDPR and PDPA, a part of data subject, data controller, data processor. Another one is DPO, data protection officers. DPO, data protection officer, forced to simplify, their duty is to consult, have to monitor, have to audit the use of personal data in the organization. DPO is a mandatory in 3 cases if the organization is public authority or the organization process the large-scale regular monitoring or the organization process the large-scale special data category. For example, if the organization is public sector, it will be in the first case public authority, or is the hospital or healthcare company process the special data category such as genetic data, biometric data, or health record. They have to employ the DPO. DPO can be employee or outsource. DPO roles is to monitor compliance, inform, advise, cooperate with supervisor authority of the national supervisors, and act as contact point. So everyone may afraid that to act as DPO, that DPO may be risk to be penalty, to be fines. It's not true because in this law, the most of penalties, most of fine, most of punishment will stay to the data controller, not DPO directly. But if DPO publish or open the secret of the of the data controller, there's another penalty too. So in internal communication, internal collaboration, DPO will collaborate, will communicate to IT to data, information security, IT, data, system. So the mandatory skills of DPO is IT risk. The first one is IT risk. Another one is legal compliance, and the third one is data management. There are some penalty in PDPA. There are several penalty rates, but there are three types of sanction: civil, criminal, and administrative. Civil in Thai is โทษทางแพ่ง criminal measures is โทษทางอาญา administrative จะโทษทางปกครอง so the punishment rate is up to 500 baht per case. For example, publish the secret or publish the data that you collect to your own benefit is maybe high penalties. In criminal measure, maybe imprisonment in 1 year is 1 year or 1 million baht. For my opinion, this is very light when compare with GDPR, because GDPR, if you seek the benefit from the data that you collect illegally, you will be fined to 4% of global annual turnover. So it's a progress rate. So if last year you have you have benefit, you have revenue. It's a revenue. If you have revenue for $100 million, and you infringe the GDPR, you will be fined around the $4 million. It's just an example. But in PDPA, this fine is just a fixed rate. But personally, I want you to wait and look for this year, because I suppose that I want to know something about the measurement punishment that may be changed or maybe derogate.